Welcome, everybody, to Legal Tech Week for April 18th, 2025. This is the show, in case you don't know where you are, where we talk about the top stories of the week in legal tech and legal innovation. I'm Bob Ambrogi. I have a blog called Law Sites and a podcast called Law Next. And our panelists today, let's see, Joe, you want to kick it off today?
Sure. Joe Patrice from Above the Law and Thinking Like a Lawyer. I am taking a break from internet research to be here. No, that may or may not become funny later. But yeah, no. So happy to join while I'm still not detained.
Um, do people hear power drills in my background coming? There's people, I gotta just mute myself. There's somebody doing work right outside my door.
You're
Nikki, how
fine.
about you?
I'd first like to thank you for grounding me in time and place because I was a little confused. And my name is Nikki Black, and I am the Principal Legal Insight Strategist at AffiniPay, parent company in my case, LawPay, CasePeer, and DocketWise. And I write legal tech columns for ABA Journal, Above the Law, and the Daily Record. And I also write our legal industry report that was just recently released.
Steve.
Hi, Steve Embry. I write the blog Tech Law Crossroads about legal technology and innovation. I also am a regular contributor to Kentucky Bench and Bar on legal technology, and from time to time write for Above the Law and One Legal.
And Victor.
Hi, everyone. My name is Victor Lee. I am Assistant Managing Editor for the ABA Journal, covering business of law and technology.
So Victor, I thought I would start with you today because you've got a piece on, well, you did a podcast episode on immigration lawyers and tech, and it seems like immigration lawyers could possibly use some tech help right now. They're all a little bit busy, I suspect. So, what did you find out?
Yeah, they're all really waiting for they're always waiting around, waiting for things to get interesting in their field of expertise. Sitting on a beach drinking Mai Tai is really, kind of boring them, and they would really like to do something. Now, yeah, so Greg Siskin, who we know is a longtime longtime legal tech enthusiast and immigration law expert and whatnot, lawyer, and he's been a guest on the show before, and I actually had him on the show before ChatGPT became commercially available. So we talked about how technology can help immigration lawyers do their jobs more efficiently, and then generative AI became readily available. I think a couple months after that. So I thought, oh, even before all this stuff was going on, I thought, oh, it might be nice to have him back on the show just to talk about how things have changed in those last couple of years, not thinking that, okay, well, I probably should have probably had him on the show back a couple of months ago. But yeah, it's obviously it's a crazy time for immigration lawyers. You know, much crazier time for people and actually it's the immigration lawyers that are actually able to represent clients. It's tough enough for them. It's even tougher for people who cannot afford lawyers or do not have access to lawyers who are caught in the immigration web. As we've seen, that you know can be even a bigger nightmare for people. So, what can immigration lawyers do to help them? Obviously, generative AI is helping them a lot. Just pare down just the sheer volume of cases. It can also help them just with regards to saving time. Like if they're litigating, filling out filling out. It's not just filling out forms. It'll help them with litigation and whatnot. And so he was just talking about that. And then also we talked about just macro issues relating to immigration policy in this country and what's been going on the last few months and what people can do if they do find themselves caught in the net. There weren't a lot of great answers, obviously, did not, and it wasn't his fault. It's because things are such in flux, things are changing, and just everyone just kind of flying, pretty much just waiting to see what's going to happen on any given day and then reacting to it. There's not really a whole lot people can do about it, but just be vigilant. Unfortunately, probably have to carry more documentation around, and hope that I really just hate to just hope that the net doesn't come for you. But um, you know, there are tools out there for immigration lawyers who are especially just kind of swimming upstream to help them, and there are tools out there for people who are pro se and can't don't necessarily have access to lawyers or can't afford them that can help them out as well. But obviously, these things aren't going to go so far if the administration is going to behave the way it's been behaving.
I'm assuming Grok, Elon Musk's AI, just tells you to immediately deport yourself when you ask.
Like, just, you shouldn't be here, so just leave.
In defense of Grok, it seems to have a
Oh,
really
you're the one
negative
defending
opinion. Well, no, it seems to have a really negative opinion of Elon. Like you always see people posting that they asked, like, who's a big vector of misinformation? And Grok will be like, seems like Elon is.
Well, wait, what did Elon say? This is totally off the immigration subject. But didn't he say something last week about how Grok is going to replace all the legal tech because he's just going to dump a bunch of cases into it and it's going to be able to
He said
answer
that a
all your
while
legal
ago.
questions?
Yeah, he said a lot of
ago?
things.
Yeah, he
Yeah.
said that. I wrote about that.
All right.
Yeah, like in December.
All right. Um, forgot what I forgot what I was going to say about Greg Siska. Other Greg Siska is amazing. I mean, he is like an example of how to of how lawyers can really be innovative in terms of using technology. Greg has been innovating with technology since like as long as I've been writing about technology. I mean, he was one of the first people out there using tech in his law practice way back when. I know Niki and Greg you guys did at least one program together at ABA Tech Show, right?
I was going to say, you'd be remiss if you didn't use that segue there, but.
Right, yeah. Well, we can segue to that in a moment. On the immigration thing. I mean, it's remember the good old days when people could get a lawyer and like go to court or something and actually have something happen in terms of due process, and it's just out the window now. It's just really scary. But
It is
Well,
terrifying.
well, just the whole thing about like, I mean, well, what was the story about, Andrew Jackson just telling the Supreme Court to I was like, well, what are you going to do about it? Just, John Marshall try to enforce your own decision. Well, I was like, well, what are you guys going to do about it? I mean, if Trump just says, you know what, I'm not going to bring this guy back from El Salvador, like, what are you going to do about it? I mean, I don't know.
they will facilitate something, whatever that'll be. But I don't know. Uh, all right. Well,
On that bright note,
yeah, on that bright note, no, I mean it is really upsetting. I mean, I did see there was another judge today who ordered, that you cannot deport people without due process, especially to other countries that they're not originally from, into prisons in other countries that they're not originally from. But it is a strange time.
Well, and they keep saying these things, and one of them is threatening to hold the government in contempt. I can't wait to see what that looks like. What's that going to look like? What does that even mean? Like, how does the
Yeah.
government hold itself in contempt? Because the court is part of the government. I mean,
I
I
mean
don't know.
that technically it's the lawyer who appears and on behalf of the government, because the actual mistake is being made on a contempt charge. Because I did some digging into this because I was wondering the same thing. The argument will be that, I guess it's Ensign is the lawyer here. It would be, you're the one who showed up in court today and made these contemptuous arguments, so congratulations, here's your handcuffs.
And then what? And
watch that guy become a martyr.
And then
he
they
lets
get
them off.
fired.
No, watch him become a martyr. He'll go on
Yeah.
Fox News, get a show, then he'll run for Senate in a few years and win.
Right. So he's gonna so if that happens, they would arrest him. And the DOJ would be asked to prosecute it. The DOJ would inevitably say no, but there's a rich body of law that says, for the purposes of effectuating the judiciary's internal powers to do its job, they can appoint a special prosecutor under their own auspices to prosecute criminal contempt against the government if the government doesn't want to do it.
And I think it's important. I mean, this should not be a political issue. It's just basic rule of law issue. It shouldn't matter, and it doesn't necessarily. I mean, there's certainly a number of Republicans who are speaking out for the rule of law and for due process. But it's too bad it gets painted as a political issue. I see that there is a lot of there's kind of a nationwide May Day thing happening around rule of law. There's going to be like lawyers events all across the country where lawyers are going to get together and stand up for the rule of law, whatever that means. But I guess it's kind of a protest, and that's a good thing, I think.
Harvey,
I attended a Bob Dylan concert last night, and as I was sitting in the audience, I couldn't help but think, will we continue to be able to have stuff like this for performers that are perhaps don't express the correct political views? And I don't know, but it was a very sad feeling.
Yeah.
I was just going to say, Harvey Wilkinson yesterday wrote an opinion in which he blasted the government as a threat to the basic intuitive sense of the constitutional order. He Harvey Wilkinson's the guy who said that you could put people in prisons and never let them see a lawyer forever back during the Gulf War or the War on Terror situation. The level to which, and it's not like he's changed, the level to which this shocks the conscious, even of people who already were like, I don't care about throwing away the key in other scenarios, should be talked about more.
But I just can't believe, like, listening to what you had just said, Bob, about, people questioning whether due process or the rule of law, it's becoming political. Like, did you ever think we'd speak these words when we started the show, that due process could become null and void, like it just could no longer be a thing, or that the rule of law would somehow be questioned? Like, I can't imagine that this is a thing we're actually talking about. And we're just sort of, I'm not saying I'm any different than anyone else, sort of going, well, I mean, it's happening. Like, what do you even do? It's such a weird reality to be in.
Yeah. That's this is why I'm hoping you're right about the simulation, Nikki. That's all I can say.
It's comforting. You got to agree with me. It's comforting to think this just isn't real, right?
Mm.
It can't be, can it? Anyway, I suppose we should talk about legal tech a little bit anyway. So yeah, so Nikki, so you were on a panel with Greg Siskin at APA Tech Show and talked about practical ways for legal professionals to use generative AI.
It's a light topic, and but it's a great segue, right? Because like it was with Greg, and it was about tech, and you're just saying how he is so innovative and forward thinking. And there's not a ton to say about it. It's more almost like, I would say, an FYI, right? Like we did talk about it, and I have been sharing on LinkedIn 5 of these tips every few days. I wrote a blog article about it for the Daily Record and republished it to my legal blog. I just provided the list. And in this article, I talked about 10 of the tips, and basically what we did, and it was, one of those 60 tips in 60 minutes type of things. And for each minute, one of us would provide a tip, provide the context, and then the document that we shared that went along with it had suggested prompts that you could use to accomplish that specific suggestion for the use of AI. In this article, I covered 10 of them, and I also provided a link to a web page that I created where I just copied and pasted all of them in. So there's a link in the article, in the blog post, where you can follow that and find that web page. It has them all listed, or just track on LinkedIn as I post 5 of them every once in a while. And yeah, that's a nice lighthearted little happy legal tech thing. So maybe we should dive into some additional insanity above and beyond this. This is pretty simple. But
Well, it was actually kind of interesting. I mean, some of the things you pointed out were, I think, things that I don't know aren't. I mean, they're a lot of them are very simple, but things maybe people aren't talking about, like helping you update your website content, or I don't know, it's just sort of things that I think you sometimes don't think about using generative AI for, like where they can be really helpful.
that's what I thought was useful about this endeavor, sort of. It's the idea that, go to the supermarket and we have so many choices, you just get overwhelmed by choices. And I think that generative AI is a lot like that for lawyers and just for people in general. There's potentially so much you can do with it. That's the idea of like sitting as a writer looking at a blank sheet of paper and not being able to get started. It gives them a concrete place to start. And I should also mention that a bunch of the suggestions that I submitted were actually pulled from the Legal Industry Report. We had a write-in section where you could ask people what do they actually use it for. And there were, I would say, probably 300 responses. I just included a small section of them in the actual report. But I tried to pull from the report ways that lawyers actually told me, legal professionals, not all lawyers, told me that they were actually using generative AI. So some of those are in the wild. What's the right term? There's some other phrase, but they're legit uses. I don't know. But from actual attorneys or legal professionals.
Yeah. Speaking of tech show, Steve, you weren't here last week, but now that you're tech show chair emeritus or whatever, I just wanted to first of all congratulate you on great tech show, great programming,
Thank you.
great stuff. As
Thanks.
I wasn't thrilled with the venue, but but that's not your fault. But the show itself I thought
A
was
lot of
great.
people weren't thrilled with the
It's
venue.
Well,
the yeah.
it's it was what it was, and we knew going in that we had some challenges, some of which we dealt with and planned for, and some like were we didn't. You know, I mean, obviously, if we'd had it to do over again, we would have done something about that big space in front of the exhibit hall and kind of seen if we could crunch that down a little bit and make it more hospitable. Um, but actually, all that being said, I was really pleased with how it turned out, and I was particularly pleased with how we all managed to work together as a team, both the board members and the staff, and it was fun to do it because it was good people, and we worked hard to be pleasant and collegial and supportive, and I think that made for a good atmosphere. So anyway, I'm kind of glad it's over though.
Yeah, I bet. Yeah,
Yeah, I
that
mean,
was
I
good.
I actually thought it was going to be even bigger. I thought it was going to be because like, first year of McCormick Place, I thought it was going to be a train wreck. I was just like, it's going to be a disaster. Everything that could go wrong will go wrong. Things are not going to start on time. People are going to be mad. And I was just pleasantly surprised. I actually thought the show went pretty well. I mean, considering that it was a brand new venue and there was so many new challenges and new, logistical hurdles to clear. So yeah, I mean, kudos to Steve and the planning board and the ABA staff. I mean, I thought everyone did a good job at like just making the show happen. Even because I mean, I was just
Yeah.
like, oh, it's going to be terrible. It's going to be a disaster. Like, so yeah, I mean, by my low standards, but no, but I actually did. I'm not trying to damn you with fan praise. I thought the show went
Thank
well.
you. You go right ahead and do that. That's fine. I'll take all the praise I can get. No, I'd actually I know that there had to have been a lot of grumblings going on, but I didn't hear many of them. I heard a few, and probably mouthed some of them myself because I mean there were some obvious things that could be done better. But um, yeah, I thought it went much better than when we first started. I was concerned, but it came together. So it was a good experience, I thought.
Now it's Legal Week's turn to move next year to Javits, and we'll see how that goes.
Mhm.
Um, all right. Well, actually, to just kind of follow up on Nikki's talk about ways lawyers can use AI, I thought I would just drop in a reference to this thing I did this week, which is not something I wrote so much as generative AI wrote for me. But Nikki mentioned the report that Affinipay did that she wrote. Within the span of roughly the last month and a half, there have been four different reports that came out on lawyers' adoption of AI, and it's probably like, wait a minute, and there'll be another one. There have been a bunch of them dropping recently. So I was just kind of curious how they compared against each other, and being lazy, I decided I would just take all four of the reports and load them into ChatGPT and ask it to generate a comparison for me. And I thought it actually came out kind of interesting. I did go through and try and verify what it told me. I actually found at least one mistake in the ChatGPT reiteration of what was in the reports versus what was actually in the reports. But besides the Affinipay report, the Thomson Reuters just came out with one this week. Smokeball had come out with one, and then there was the ABA annual Legal Technology Resource Center survey that they put out that covers a whole bunch of legal tech, but I focused in on the AI stuff there. And I thought it was kind of interesting just because there were a lot of consistencies among the reports. Um, Particularly, I think just with regard to adoption, they all sort of fall, sort of say that roughly this range of 20 to 30% of lawyers are kind of regularly using Gen AI in some way in their practices. I think Smokeball put it a bit higher. There's some distinctions between the extent to which firms have adopted versus individual lawyers. Uh, that seems to be the right number right now. I mean, given conversations you have with people, you might think it's even more, but that it does seem to be some consistency among these surveys anyway. Um, and then, in terms of use cases, apart from some of the ones that Niki was just talking about, I mean, it does still seem that primarily, if you look at these surveys, legal research is right up there, document review is right up there, document creation, summarization. I mean, sort of these basic functions that we've come to understand are associated with generative AI, reflected in the data that's how lawyers are generally using it. With pretty much legal research more or less leading the pack in most of these surveys. Um, and then, in terms of adoption, otherwise, a lot of concern across all these surveys with the ethics of using AI, the accuracy of using AI, concerns about confidentiality. Um, so I don't think anything really all that exciting came out of this comparison, other than to show that more or less these four different surveys that looked at very different kind of parts, in some ways different sectors of the community, of the legal community, different the surveys were different sizes. I think the Affinipe was by far the largest selection of respondents of any of these surveys. But again, they all kind of came out similar. So I don't know, I thought that was kind of interesting.
I think it's really interesting because generative AI and AI in general are changing so quickly right now that these, every few months, I feel like you need to have a different survey, giving you a sort of a um, benchmark for where the legal industry is in terms of AI use because it's changing over time pretty quickly. But I also think that combining these four as you did, I haven't checked and seen exactly when the others actually conducted their surveys. I know that ours was August through October, I believe. But it, it there is a significant difference when you break it down, at least when we broke it down. Granted, the number of lawyers who are in the larger side, larger firm size, was a smaller percentage of ours, but when you break it down by firm size, there is a big difference. So the fact that these different surveys survey different aspects of the market, and then when you combine them all the way that you did, I think that that's particularly useful, even though it seems like you did a really simple thing and ChatGPT did the heavy lifting for you. It really provided a really useful benchmark though, because it took four surveys that were conducted at about the same time, had similar questions, and surveyed different areas of the market, different levels of the market. And putting it all in one place shows that it's interestingly pretty consistent across the board in terms of use, uptick in terms of usage. And I think that that's not an inconsequential finding. So I think it was kind of cool that you did that.
Yeah,
I
it's also, yeah.
Oh, I was just gonna
Oh,
say.
were you gonna say something, Joe? Yeah.
Oh, I was just gonna say, because I wrote about one of those reports this week too. Let me see if I can find it. I read about the Thomson Reuters one, which one aspect of it that I thought was a kind of a unique bit that I thought was interesting was it seemed as though their finding was that people are using it and uh, people are using AI and clients are asking for it and yada yada yada, and they found that almost nobody's doing any serious ROI research. The results of their survey was that nobody's seems to care about what does this even mean? Which I thought was interesting because it in a world where we've tried to quantify so many things and operations and blah 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 blah. It seems like the biggest thing going down the pike at us, nobody seems to care about figuring out what it's worth. And all I could think, and what my piece kind of concludes with, is whoever figures this out first is on the battle between clients and law firms. Whoever figures out the ROI question first is the one who's going to win. If the clients figure it out, then they're not going to stand for $10,000 an hour bills. And if the law firms figure it out first, clients are going to have to deal with $10,000 an hour bills.
I love that article. I included it in my
Oh, good.
so and I think you raised some interesting points, and you know it's hard to measure the ROI right now, even though the benefits seem very clear. The return on those, potential benefits is unclear. So,
Yeah.
I think you're right, and it's an interesting thing to think about, and it'll be interesting, I think, over the next year or two, as as it becomes fully embedded and integrated with all the legal tech products people are already using, and then they start to be able to track that ROI better by billable hours or whatever the case may be, like through their billing or practice management systems. Then maybe they're going to have a better sense of whether people actually are becoming more efficient or not. So,
I guess all that's true, but from on the law firm side of things, I mean, it's almost a loss on investment, not a return on investment, because you're using a generative AI tools to replace work that might have been billed for before. So how can you? I mean, unless you adopt a different sort of fee structure and go to alternative billing, I'm not sure. I'm not sure the law firms want to know the answer. I can see why clients would want to know that answer because it makes a big difference to them.
That's a great point. And if I can hijack conversation for a second, this is a good place. I put a bunch of stories in. I was kind of like, here's a bunch of things we could talk about. So I'm kind of all over the place. I'm going to hijack off of that.
Not going
The
to your porn
story.
story now.
No, not that one.
I thought that's where he was going. I
That
was waiting for the shoe to
that would have
drop.
been that would have
I was like,
been
how's
one.
Joe going to get from this
Yeah.
to that? I was like, I was waiting for it. I thought maybe hijack. You were going to then maybe like take
Yeah.
that a little bit. I was like, nah, I don't know.
In fairness, you were talking about billable hours, and so there's a, but no.
There you go.
So a story that's not even mine, but JM wrote this story in Legal Tech News that I read this week that I thought was really interesting, and a lot of what she says is, very good and like right on, and I have no quibble with or whatever, because this is what she does. That said,
Not
there
a
was
single emoji in that story that I could see.
I assume that's ALM's fault. But when I was looking at it, there was one point that she makes that I thought about, and the more I thought about it, I thought, well, this is an interesting question, and it goes off of what you were saying, Steve, about the model changing. She kind of raises a prospect that the disruption that AI might cause might lead to more and more high-profile, elite big law partners going solo or setting up little boutiques because they have AI and they can use that now. Kind of the logic being that if you see AI as the new form of leverage, the model used to be you have a bunch of associates down there and the pyramid scheme billing for you. If AI becomes that form of leverage, then you don't need overhead. So why don't you just go off on your own? Which I think makes a lot of sense and certainly is probably true in certain practices. But then I started thinking, in particular on transactional work and stuff like that, maybe the leverage is not that AI is replacing is not so much the associates as the knowledge base, because I think the skill set you have when you're when you're dealing with AI, like this is always the like Google, Facebook argument that like it's not their technology, it's the data that that they're all sitting on. Data is everything, and there's something to be said for if I'm a high-end partner trying to service those clients, they're not coming necessarily for me or my associates as much as they're coming for the knowledge that me and my associates can leverage. And at that point, I would want to go to a big firm if I'm a partner in that kind of business. I want to go to a firm where I can say, the AI that I'm going to use is sitting on top of 30 years of really good drafts that deal with every context under the sun, and it's going to have better understanding of what works and what doesn't. And if that's what AI is doing, then the data that it has is the most important thing, at which point big law firms and the big four and all that are going to have an advantage. So that was my point, a long way around. The one takeaway I had from it that I kind of quibbled with was, will it lead to more small firms or will it just lead to the big firms becoming more powerful as data centers than body centers.
It's an interesting point, Joe, because I also wonder, like, is it going to make it even more easier for a partner and five associates to pick up the five associates and his generative AI tools and go someplace else to
Right.
another big firm? And when we're already
Exactly.
seeing that all over the place. I mean, that's like it's a it's like the transfer portal or something. People are moving and moving and moving, and so I sort of wonder if that's just going to increase that and certainly give those partners more power.
Yeah.
And I mean, the whole notion of law firm culture, I think, is just like out the window
Right.
at this point.
Like,
So
so I'll speak about, I was on the litigation side, so I don't really know as much about transactional, but speaking about my old firm, which I'm now like 20 years removed from, so I don't really have too much loyalty necessarily. But if I were a partner doing certain kinds of sovereign cross-border transactions at some firm, I might I might be very interested in moving in an AI-driven world. I might really want to move to Cleary so that I have access to the knowledge base of all the people who've been really experts in that for a long time, because they're retiring and I want to have access to that knowledge that's the kind of proprietary work product that's sitting in there. And, there are some questions about using client data and yada yada, but assuming you have, and I think everyone will, built guardrails and protections around that stuff being used anonymized and whatever. I want access to that database. And I think I would sell to my clients that I'm at a platform where I have access to all this accumulated knowledge over decades. Anyway.
Yeah, I think there's something just to that. I think eh, that accumulated knowledge over decades is only of so much value, right? I mean, it's going to be the more recent knowledge that's going to be the most valuable, and probably if you have a really a pretty specialized practice, you have access to a lot of that in a form where you could probably bring it with you
Sure.
in some ways. I certainly don't see them going into solo practices because I don't solo. It's really hard to sustain a sophisticated uh, you know, commercial or transactional practice in just a with just a solo in just a solo firm because you need to be able to tap into other skills and other capabilities that beyond just what you have in your own head. But I could see the move toward more boutique firms. I think that could be something that we start to see more of over the next decade or so.
I guess I am very much coming from litigation where I do think you kind of need to be much more modern. And maybe I'm being biased here. It's always struck me whenever I would talk to some like structured finance person or something like that. They were like, yeah, yeah, yeah. Well, our models from 1982, because like everything was just always the same deal over and over again. You know, little nuances on the edge were the only thing that really changed, and having the an understanding of those nuances when they did them 15 years ago was the hotness. Uh,
Yeah.
but again, maybe I'm just being biased against transactional people because they're weird.
yeah, they're not real lawyers like us.
Um, yeah. What in your bucket full of stories, Joe? Again, before we get to the porn one, there was another interesting one that you had this week relating to something completely different from what we've been talking about so far today, I think.
Yes. So the other story, let me get my sorry, I'm
You want me to tell you what it was
get my
about?
no, no, no. I'm putting my time code in,
Oh,
because
good for
I'm
you.
supposed to be
Ben
doing
will
that.
love you.
Uh, yeah. So was this one was interesting, and it on its face was not a legal tech story at all. But there's a little bit of context. A while back, I wrote a story about a boutique firm that sued another firm, a big firm, I think Wilmer Hale, sued them. No, no, Winston and Strawn, I think, or whatever, one of the W firms. They had sued them, arguing, "You violated our copyright in our filing." This boutique had filed a motion a similarly situated client represented by the big firm was just like, oh yeah, no, the same facts apply to us, and they more or less copied it, changed around what they needed to. And the boutique was like, this steals our intellectual property. I thought this argument was stupid, given that it was a publicly filed document, whatever. There's almost no good case law to suggest that you can do this. Like, there's a couple of cases, and they're like people bugging out on joint defense agreements and stealing things and filing first, and stuff like that, which it was not there. Anyway, I said, look, the idea that this stuff that's publicly filed is not public domain is insane and violates the whole concept of common law. Fast forward, a there's a putative class action in Puerto Rico that a bunch of municipalities of Puerto Rico have filed against some defendants. San Juan has was not in on the first bite at it, but has now decided to get in, and so they filed a copycat complaint, more or less the same. There are reasons why San Juan's representation is dumb because they did stuff like fail to, accurately change every instance, and it kind of looked lazy and sloppy, and that agreed. But the judge cracked down on them with a framework of intellectual property, like crack down on them and saying it's unethical that you even tried to copy a complaint, which I think is ridiculous because, again, public domain, and why wouldn't you want to? If you think that complaint is good, go for it. Also, complaints aren't the whole of litigation. They're a starting point. Like, the lawyer still has to do stuff afterwards. It's not like it's stealing anything. I make the analogy, it's kind of like arguing that the NFL needs to crack down on everybody else who runs the same play, who has the same play in their playbook. Like, no, of course not. It's got to be different because the world is different. But how it became a legal tech story is the more I read what the judge said and thought back to this earlier case, I started worrying that it seems like there's an effort to create what has never been true before, but to create some sort of intellectual property protection for lawyers' filings, which seems especially worrisome in a world where we're moving towards AI and think that AI offers at least some value to the legal profession. If everyone starts trying to assert intellectual property rights over the stuff they've written that would theoretically become training for those models, it's gonna mess the system up.
I think it's a really interesting issue. I was trying to research this afternoon uh, without benefit of having any actual legal research databases, using using my perplexity and chat GPT, what the law is on this. And there isn't, it's really hard to find any clear answers on this. But so, I mean, you raised an interesting point about the legal tech issue. I mean, the other legal tech issue is partly just that, like, the judge chastised the lawyer for, like, not even changing the references to the parties properly, like, from company to municipality or whatever it was. I mean, you could just could have just done a find and replace. I mean, not very sophisticated legal tech
Yeah.
that the person didn't even think to do that much on the document. But I don't know.
And it reminded me of the classic, like, all these chat GPT problems we've talked about, where we've been very clear. It's not that the technology is bad, it's that a lawyer was lazy and didn't do the work that they were supposed to do. I don't think there's a problem copying a complaint, but you need to do the work of going through and making sure you're changing the names and doing like that shows that I heard once that those writers that always get in the news where some musician some band has a writer in their contract that's like, I want a bowl of M&Ms and no brown M&Ms and the whole thing. It's like ridiculous stuff.
It's Van
I
Halen.
read
Yeah, it was Van
Yeah,
Halen.
okay, yeah. I read something once, I don't know how true this is, that the reason was they didn't care about brown M&Ms. It was a proxy for, did you
It was a
follow what we
test.
said to the
Right.
letter?
Yeah.
Yeah.
Yeah,
That's exactly
Uh,
David Lee
right. Yeah.
Roth. David Lee Roth came up with it. Like, he's actually,
okay.
I mean, he acts like an idiot, but he's actually a pretty smart guy. Like, I guess he was saying that in the early days, because Van Halen, they would always do like stuff where it's like, one of the guys was swinging from the rafters, and
Yeah.
they had like some pyro stuff, and so they had a couple incidents where, like, maybe things weren't set up properly, or people weren't, like the weight wasn't accounted for on certain things. So they snuck the brown M&Ms thing in just as a test. So that way, if they went to the dressing room and they saw a bowl of M&Ms that had the brown ones in, they were like, okay, well now we got to go through the contract to make sure you did everything correctly. So it
Yeah.
actually did serve a purpose.
Yeah, exactly. And I think so good. I'm glad I know that that's actually real because I heard that once and I was like, I think that's really smart if it's true. So glad that that's true. And yeah, and I think that it's much like that. If you are not if you've copied a complaint and you didn't go through and change to make sure your client's name is in all the right places, then that is indicative of a laziness that probably is bad. No quarrel with that. But I don't think that the mere idea of trying to copy it should be a problem. And yet, this order frames spends a lot more ink on the idea that copying is the sin, not the changing. And I was like, no.
Yeah, I don't know. I mean, it's um, I mean, well, I think did you mention the fact that this lawyer then said, well, we're actually cooperating on this case with the people who
Hmm.
authored the original brief, so it wasn't really copying. We're sharing resources, but I mean, it does. If you put a lot of work into a brief, and this is kind of like this is my beautiful thing. I've crafted these wonderful arguments, put the words together just perfectly. It would certainly piss me off to find out that somebody else just picked it up and used it whole cloth
Well,
like that, and.
well, so let's do this. And so I can hear that. I still think I wouldn't care about it, but a brief is a little bit different. There's a little bit of rhetorical muscle flexing. A complaint, I mean, it's a series of paragraphs that are like defendant X lives at 123
Yeah.
Birdsong Lane, right? Like come on, people.
Yeah, I guess
Everybody
that's right.
starts from especially if you're in a smaller firm or a solo, from the forms that are provided. It used to be in the books, right? And then it was on Westlaw or LexisNexis, but there are forms that, accompany the laws, and there are forms that have been created separately in other books that treatises and stuff that people can use. And like everybody works off of those. So how far back do you have to go until it's everything's copyrighted and I mean, where does it stop? Like, when do you decide that this has become original work and it's not just a replica of these forms that have been made publicly available for this use?
Yeah. Yeah, like Andrew says, you can't copyright government edicts or facts, but this isn't a
Well,
government filing.
so
It's a
what's
public
one
thing.
thing that was interesting about the opinion, and I go through and break down kind of because the judge doesn't really have support for the specific thing that she's mad about because there isn't any, but she makes a series of analogies, and I kind of break down why the analogies don't work. And one thing is on that question about like government edicts, she's like, "There's plenty of law that you can't cite cases and then not take language from cases without citing them." And I was like, "Sure," because the reason everybody wants to cite a case. If they're not doing it, it's because there's a reason. It's because they don't want to cite it because somebody would then look at it and go, well, wait a minute. Is the next line because slavery is good or whatever it is? And so they don't want to do that. And they're trying to hide the ball. So that is misleading, right? And that understandable why that would be true. The idea that you're copying somebody else's complaint, like you're not trying to you aren't obligated to like reinvent the wheel on a complaint. A complaint. Anyway.
Yeah, right. Any other thoughts
Oh,
on plagiarism? We could talk. I mean, that could potentially be a transition to tech competence because had the lawyer known how to do a find and replace, at least he could have cleaned the darn thing up a little
yes.
bit and raised some other issues. And I don't have not a big tech competence story, but an interesting one I thought this week because with the New Jersey Supreme Court, which has been considering whether to adopt the duty of technology competence, and I have a page on my website where I've tracked this for a number of years, and 40 states have officially, excuse me, formally officially adopted the duty. New Jersey had been pondering it and decided this week not to adopt the duty of tech competence, but to add a tech CLE requirement making it only, what was it, I said, the fourth state, I think it is, that has a tech, any kind of a tech CLEs requirement. So it seemed like a weird kind of a thing for the court to go that way on tech CLE, but not that way on duty of tech competence. And the court did not issue any kind of an order that I'm sure they must have issued an order somewhere, but it wasn't made public. Instead, the New Jersey court just put out this like notice to the bar that the court had done that without an explanation. I actually reached out to the New Jersey court's media relations office to see if I could get an explanation for why they did this. And the person I talked to said, "Oh yeah, we'll get right back to you," and they haven't gotten back to me. So I don't know. I don't know what the story is there, but I mean, one person said, maybe it's like a measurement issue. I mean, you can measure a lawyer's compliance with tech CLE. You otherwise really can't. There's no sort of teeth in the duty of technology competence that you can track or measure. So I don't know if that's it or not, but I thought it was interesting.
I mean, what if it's just this? What I was thinking was, you have competence. Maybe they're assuming technology competence is part of that general competence, which is why they're requiring a CLE credit in tech to show that this person has somehow learned about tech and therefore satisfied this sort of underlying assumption that technology. I mean, there's a lot of big jumps in there, I realize, but and who knows what the tech CLE could be about how to use, I don't know, word processing tools. I don't know how they define a tech CLE, but that certainly doesn't, just because you know how to use like Google Docs doesn't mean, or like Office, whatever, Word Online, whatever, whatever, I don't even know what you call Word Online anymore. Is it Office 365 Word? I don't even know what it is, but is the assumption that, I mean, if you learn that, therefore you're tech competent, I agree. It's sort of strange not to adopt both, but maybe it's just one of those things where they're assuming that competence is a general, broad concept that therefore just encompasses technology these days. Is this elasticity to competence? I don't know.
Yeah, they didn't even define what the CLE requirement is. Their notice said we will be providing details in the near future on what is a quote unquote technology related subject. And I mean, how much can you really learn in a 1 hour tech CLE every 2 years? I mean, I don't really know how that really does all that. I mean, it's a nice thing symbolically, I think that they do that, but practically speaking, I don't know that there are many lawyers out there who are going to become a whole lot more tech competent by virtue of a 1 hour CLE every 2 years. What are
What were
the other
three
three?
before I asked? I
It
can't
was
remember.
Florida, South
Not South, I
Carolina.
was gonna say, yeah.
Um,
I can't remember. Louisiana, maybe? No.
well, New York has, it's technically
Cybersecurity.
not a tech CLE, it's a cybersecurity CLE, but I'm counting that as one of them. So the New York, Florida, and South or North, I think it's South Carolina, um, are the ones that have that requirement.
I thought there was one more, but I might be mistaken.
It's fortunate, there's one other state that has a requirement for new lawyers, but not for not like an ongoing requirement. I forget which state it is, has a requirement that new lawyers go through a course in technology. I'm not even sure. I think it's a cybersecurity and technology course, but it's a one-time requirement, not an ongoing CLE one. So,
Yeah.
all right,
You know what?
10
You know
minutes. We're
what?
gonna have to. We have 10 minutes left. We have a hole to fill. Maybe
Oh
we should
God.
stop
Oh
beating around the
God.
bush here.
Oh geez. Oh wow. Um, wow. Yeah, no, I was if you were tech competent, maybe you would understand a few things about how the internet works. This story comes to us from a meme group that is always fun on Facebook. But they had found somewhere someone had posted, a potentially Reddit, I'm not sure, a thing that said, my friend showed me this email he got from HR. It's not looking too good for him. With that auspicious beginning, I will say that the email from HR explains Jeremy, we don't know the person's full name, thank God. Jeremy, IT informed us a lot of the company's internal bandwidth was being utilized by a site called Jerkmate by your user ID. Please consider this a warning. Uh, so, so at the company, apparently not aware that people can track the websites that you go to on their internet. This person was going to this porn site. I will then say they have a table to, to verify their work as an HR group, saying that he's been there 64.56 hours, accumulating data usage of 162 some odd gigabytes. I have many questions. Some of these questions are I want to know how big the window they're monitoring here is, because it is one thing if this was over the course of a year. Uh, if this is over the course of a month, I wonder 64 hours over the course of a month. I feel like at the point that you have that much free time, you could just go home. You don't you don't really need to stay in the office. I understand that FaceTime matters for bonuses and stuff like that, but not as much as your billing software, which in this instance, the software was picking up other stuff. I also don't know quite how you think you're going to bill for this time, right? Because theoretically, if you're sitting in the office doing this, you're doing it with the eye toward you're going to actually mark this down as billable time, like professional reading or something like that. And maybe it's non-billable. Uh, I'm not sure what the appropriate code is or the diary entry you're supposed to write. I assume there's AI that is capable of doing that. Uh, yeah, a lot of questions. Now, this person works for a consultancy, it says, so maybe they don't bill time in the same way as law firms do. I'm not sure, but it does make me think that it confirms a lot of things I think about consultants, because it seems to me as though every time I've dealt with a consultancy, I'm like, did you actually do anything? Where you guys just, you know, you know,
Circle jerk.
just kind of like a circle jerk, like a bunch of intellectual masturbation that like turns out like, well, what was in New York here, we had the situation where they paid McKinsey something like $10 million to deal with the trash problem, and McKinsey was like, what if garbage cans? And then like walked back. Uh, which again, new for New York. I didn't really realize how new it was for New York till I lived here, and I was like, oh, well, you just put garbage out and they pick it up every day. I don't know what that did to Oscar's home life, but because I grew up thinking there were garbage cans in New York, but here we are.
I feel like if there was going to be a billable, like a code for that, it should be 80085.
Mm,
Like it would
Ah,
have.
I see what you're doing there. That was the Gen Xist Gen
yeah,
X thing
the,
ever.
the
Yeah,
calculator, we've turned it upside down though, I think, right?
yeah.
Maybe I did the letters wrong in the wrong order. The
All
numbers are
right.
in the wrong order.
I don't even get that one. What is that?
Boom.
So the old calculators, like what you would do is you would type in 8008 and then 5, I think. Yeah.
Five, yeah.
And then you like
Yeah,
turn it upside down and it would spell boobs. And
I
right. Well,
see.
like that, it is boobs. Like if you
Oh,
do it,
oh,
yeah,
okay.
you have to kind of do 2008, and
yeah.
then it's
Oh,
upside
maybe
down. But
I
yeah,
don't know, or something like that. I didn't do it a lot, so I've forgotten how to do it, I guess. But yeah, I was also gonna say this is just I shared this in our journalist chat, but this is just the modern version of what happened when I first started as an associate in a law firm in Rochester, and there was this I heard that this
okay.
incident story about this guy who had been a judge's son who was an associate there, who had been politely asked to leave at some point because they discovered he'd racked up, I don't know if it was hundreds or thousands of dollars in like 1-900 calls late at night when he was working late hours at the firm. So, I mean, this is not the first time and it won't be the last. I'll be interested in seeing what it looks like when we have like AI simulated porn available and how much that costs and what that looks like. So I'm looking
Well,
forward to
hopefully that'll
that
bring the
part.
cost down.
I don't know.
But
But
maybe the guy was doing research Maybe he was doing research because, I mean, trying to ban porn is like one of the administration's goals, I think, right? So maybe he's, trying to get research and trying to learn about, things so that one day he'll be well positioned to either defend it or go against it.
Yeah, it could have been legitimate. So there, another legal tech angle is that there are a number of passive timekeeping programs out there these days. I think, does my case even have some passive timekeeping built into it? So
Um,
how would it account for time spent surfing porn sites?
Well, my case's tool, and a lot of them, often only track work done within the program. And then there are a few others, because I've written about these for the ABA Journal, that will actually track what's done on your entire computer, like on your desktop. So my case would not pick that up because it is a website opened up outside of my case. So that would not be captured by Smart Time Tracker in my case.
I feel like Michelle Spencer's comment requires further explication, but that may be for another time. Um,
Well, at least a 14-year-old, you can excuse it, right? Because they're not going to know to like log out and then close out all the passive timekeeping, slash spy programs on your computer, workplace productivity programs, and make sure that you're not being tracked. I mean, this guy's what, a consultant for what was the company? I don't know, but like, yeah, I mean, probably making six figures. Come on, use your brain.
the 14-year-old probably knows more about that than the 35-year-old lawyer.
Actually, no, that's true. Now that I said that, yeah, I think you're.
Why did the guy just use his phone, assuming it was not a firm issued or company issued phone, right? Like, what's he using the laptop for? Like, who doesn't understand that work can track what you're doing on your laptop? Like, I don't understand. Who doesn't get that?
All
See,
right.
this is why work from home was a good idea.
All right. Well, that's a hard one to follow. So I think we might have to just wrap it up at this point. Any final thoughts? Anything else anybody wanted to raise for the good of the order before we wrap up today? If not, then thanks to all of you for joining today, and see you back here next Friday.
Well, everyone.